Chapter 3. Comparison of Indian constitutional schemes with other countries. A constitution of a country needs to reinvent itself to keep pace with the global changes. These global changes help in strengthening of principles and values of the Constitution. Hence, comparative analysis is important for understanding the core principles, structure and evolution of Indian Constitution. Introduction. Various political systems prevalent across the world are explained below. Dictatorship is a form of government in which the ruler is an absolute king who is not restricted by a constitution or laws or opposition from the people. Democracy is the government by the people, exercised either directly or through elected representatives. Republic is slightly different from a democracy. It is a government in which supreme power resides in a body of citizens entitled to vote and is exercised by elected officers and representatives responsible to them and governed according to law. Black circle anarchy is the absence of government, the state of society where there is no law or supreme power, a state of lawlessness, political confusion. Salient features of the constitutions of various countries. United States of America. The United States of America is a federal republic consisting of 50 states and a federal district. Main features of its constitution are as follows. President is the head of state and the head of the government. It is a federal state that emerged from an initial agreement between a number of separate states. (42) General Studies, Mains, Paper 2. France. In the United States, the Constitution is king. Only laws passed through the mechanisms established by the Constitution are valid. Furthermore, any law that is inconsistent with the limitations, structures or principles established by the Constitution is considered, by definition, invalid. Another prominent feature of the U.S. Constitution is its scheme of separated powers. In USA, executive is separated from the legislature and judiciary. The framers were well aware of the need to preserve liberty while establishing order with the new Constitution. United Kingdom. The United Kingdom of Great Britain and Northern Ireland, commonly known as the United Kingdom, is a sovereign state located off the northwestern coast of continental Europe. The country includes the island of Great Britain, the northeastern part of the island of Ireland and many smaller islands. The United Kingdom's form of government is a constitutional monarchy with a parliamentary system. It consists of 4 countries, England, Scotland, Wales and Northern Ireland. Main features of its constitution are as follows. The United Kingdom is a unitary set of government, as opposed to a federal state. The legislature is bicameral in nature. The judiciary is independent. The Constitution is not written in the sense of having a single document defining the powers of government and rights of individuals. Nevertheless, many sources of constitutional law are written, and these together with the non-legal rules make up the British Constitution. The Constitution is flexible and based on continuity of development. In the absence of a written constitution having the status of fundamental or higher law, the concept of parliamentary sovereignty or legislative supremacy represents the cornerstone of the Constitution. There is no strict separation of powers between the executive, legislature and judiciary, although a separation of functions exists and the concept retains importance under the Constitution. France is a unitary semi-presidential republic located mostly in Western Europe. The current Constitution of France was adopted on the 4th of October 1958. It is typically called the Constitution of the Fifth Republic and replaced that of the Fourth Republic dating from 1946. Since then, the Constitution has been amended 18 times, most recently in 2008. Salient features of its Constitution are given as under. The preamble of the Constitution recalls the Declaration of the Rights of Man and of the Citizen from 1789 and establishes France as a secular and democratic country, deriving its sovereignty from the people. It provides for the election of the President and the Parliament, the selection of the government and the powers of each and the relations between them. It ensures judicial authority and creates a high court for judging the president, a constitutional council and an economic and social council. It was designed to create a politically strong president. Black circle. It enables the ratification of international treaties and those associated with the European Union. The Constitution also sets out methods for its own amendment either by referendum or through a parliamentary process with presidential consent. Russia. Russia is a federal semi-presidential republic, comprising 83 federal subjects. Salient features of its constitution are given as under. The Russian Constitution is based on world standards for human rights and basic principles of democratic state building such as ideological neutrality of the state, political pluralism, competitive elections and separation of powers. The Constitution establishes a semi-presidential system resembling the French system but with stronger executive power due to increased independence of the president in comparison to the French model. Constitutional framework. 43. The President of the Russian Federation holds primary power in the Russian political system. The President, who is elected for a 6-year term, following the 2008 amendments to the Constitution, is the head of state and the Supreme Commander-in-Chief of the Armed Forces of the Russian Federation. The Constitution prescribes that the government of Russia is the executive branch of state power and consists of a prime minister, chairman of the government, deputy prime ministers and federal ministers and their ministries and departments. The legislature's innate checks and balances are reflected in the ability of the Federal Council to examine and subsequently revise or reject legislation passed by the Duma. The Russian Constitution provides for a constitutional court, a Supreme Court of arbitration and for the development of various lower courts. In contrast, the Constitution withholds several areas of traditional court jurisdiction from the court and gives them to the President. Germany. Germany is a federal parliamentary republic in Western Central Europe. The country consists of 16 states. Salient features of its constitution are given as under. The basic law for the Federal Republic of Germany is the Constitution of Germany. It was approved on the 8th of May 1949 and with the signature of the Western Allies of Second World War on the 12th of May, it came into effect on the 23rd of May 1949. The basic rights are fundamental to the basic law, in contrast to the Weimar Constitution, which listed them merely as state objectives. The basic law established Germany as a parliamentary democracy with separation of powers into executive, legislative and judicial branches. Black circle. The executive branch consists of the largely ceremonial federal president as head of state and the federal chancellor as the head of government, who is generally the leader of the largest grouping in the Bundestag. The legislative branch is represented by the Bundestag, elected directly through a mixture of proportional representation and direct mandates. The judicial branch is headed by the Federal Constitutional Court, which oversees the constitutionality of laws. Basic law may be amended by an absolute two-thirds road majority of the Bundestag along with a simple two-thirds road majority of the Bundesrat. Germany has switched between confederal, federal and unitary rule since the German Confederation was founded in 1815. The current Germany is a federal system of states. Japan. Japan is a constitutional monarchy where the power of the emperor is very limited. As a ceremonial figurehead, it is defined by the constitution as the symbol of the state and of the unity of the people. Its constitution are as follows. Salient features of The Constitution provides for a parliamentary system of government and guarantees certain fundamental rights. The Constitution, also known as the post-war Constitution, which is most characteristic and famous for the renunciation of the right to wage war contained in Article 9 and to a lesser extent, the provision for de jure popular sovereignty in conjunction with the monarchy. It is a rigid document and no subsequent amendment has been made to it since its adoption. Legislative authority is vested in a bicameral national diet, and whereas previously the upper house had consisted of members of the nobility, the new constitution provided that both chambers be directly elected. Executive authority is exercised by a prime minister and cabinet is answerable to the legislature, while the judiciary is headed by a Supreme Court. China. The Fourth Constitution of the People's Republic of China was adopted in 1982. It vests all national legislative power in the hands of the National People's Congress and its Standing Committee. The State Council and its Standing Committee are made. '44. General Studies, Mains, Paper 2. India. The Constitution of India was framed by the Constituent Assembly set up in 1946 under the provisions of Cabinet Mission Plan. Dr. Rajendra Prasad was the president of Constituent Assembly and Dr. B.R. Ambedkar was the chairman of the 7-member drafting committee which drafted the Constitution. The Indian Constitution is the lengthiest and most detailed written constitution in the world. Though most of the features of our Constitution are substantially borrowed from others, the framers gathered the best features of each of the existing constitutions and modified them according to the existing needs and conditions of the country. The preamble of the Constitution declares India a sovereign, socialist, secular and democratic republic. It highlights justice, liberty, equality and fraternity as objectives of the Constitution. The Constitution of India consists of a preamble, 22 parts and 12 schedules. Although it is federal in nature, it has a strong unitary bias. Responsible for executive role rather than enacting the laws. This basic division of power is also specified for each of the territorial divisions P's province, country and so forth, with the provision in each instance that the latitude available to authorities is limited to that specified by law. Some of the other salient features of the Constitution of China are as under. Universal adult suffrage to all citizens above 18 years to choose People's Congress members up to the country level. Actual decision-making authority in China resides in the state's executive organs and in the CCP, Chinese Community Party. At the national level, the top government executive organ is the State Council, which is led by the Premier. The distribution of powers among the various organs at the top of the CCP: the Standing Committee of the Political Bureau, Politburo. The Political Bureau itself and the Secretariat has varied considerably. Parts of Indian Constitution. The articles of the Constitution are grouped together into the following parts: Part 1, Union and its territory. Part Citizenship. Part 11, Part 12. Relations between Union and the states. Finance, property, contracts and suits, trade, commerce and intercourse within the territory of India. Part 1, Fundamental Rights. Part ZIL. Part 14, Services under the Union and the states. Part 4, Directive Principles of State Policy. Part EVA, Fundamental Duties, 42nd. Amendment Act 1976. Part XIVA, Tribunals, 42nd Amendment Act, 1976. Part 15. Elections. Part 5, the Union. Part 5, the states. Part 16, Special Provisions relating to certain classes. Part 7, States in the B part of the schedule. Part 17, Languages. Repealed by 7th Amendment Act 1956. Part VIL, the Union Territories. Part 9, the Panchayats. Part IXA, the Municipalities. 74th Amendment Act, 1992. Part 18, Emergency Provisions. Part 19, Miscellaneous. Part 20, Amendment of the Constitution. Part XB, the Cooperative Societies. 97th Amendment Act, 2011. Part 21, Temporary, Transitional and Special Provisions. Part 10. The Scheduled and Tribal Areas. Part 22, Short Title, Commencement, Authoritative Text in Hindi and Repeals. Constitutional Framework. 45. Sources. Features. South Africa. Procedure of a referendum. Election of members of Rajya Sabha. Canada. Borrowed features. Of Indian Constitution. Indian Constitution has assimilated various features from other countries into its domain, which imparts it a special character. Following are the borrowed features of the Constitution. Scheme of federation with a strong center, distribution of powers between center and the states. Residuary powers with the center. Appointment of state governors by the center. Ireland. Black circle concept of directive principles of state policy. Method of election of president. Black circle nomination of members in the Rajya Sabha by the president. Idea of republic and ideals of liberty, equality and fraternity in the preamble. France. Comparison of Indian Constitution. Written Constitution. A written constitution is a formal document defining the nature of the constitutional settlement, the rules that govern the political system and the rights of citizens and governments in a codified form. Comparison of written constitution of India with other countries is given below. Sources. Features. UK. President as a nominal head. Cabinet system of ministers, post of Prime Minister. Parliamentary type of government, bicameral parliament. Lower house more powerful. Council of ministers responsible to. Lower house speaker in Lok Sabha. Rule of law. Single citizenship prerogative writs. U.S. Written constitution. Executive head of state known as president, and he is being the supreme commander of the armed forces. Vice president as the ex officio chairman of Rajya Sabha. Fundamental rights Supreme Court. Provision of states, independence of judiciary and judicial review. Preamble. Removal of Supreme Court and High Court judges. USSR. Fundamental duties 5-year plan. Ideal of justice, social, economic and political, in the preamble. Australia. Concurrent list. Language of the preamble. Provision regarding trade, commerce, and intercourse, joint sitting of 2 houses of parliament. Law on which the Supreme Court. Function, i.e. procedure established by law. India, it has written and longest known constitution. USA, it has written constitution which is a product of 1787 constitutional document and subsequent amendments, the congressional statutes, executive orders, judicial interpretations and the political conventions. Great Britain, its constitution is unwritten. Only small portion of British constitution is covered by written documents. The British constitution is an evolved one and not enacted one. Various sources of British constitution are conventions, great charters, statutes, common law, legal commentaries. France. Since French Revolution, France has changed its constitution quite often. The present French constitution, which established the Fifth Republic, is a written constitution. Japan. Germany. Suspension of fundamental rights. During the emergency, Japan, the present Constitution of Japan became operative in 1947. It is also a written constitution.
Ditambah.
46. General Studies, Mains, Paper 2. Flexibility or rigidity. A flexible constitution is one that can be changed by ordinary lawmaking process, and the one which requires a special procedure for amendment is called NGID. Comparison of flexibility or rigidity of Indian constitution with other countries is given below. India, the Constitution of India is more flexible than rigid. It is only in cases of amendment of some provisions of the Constitution that requires ratification by state legislatures, and even then legislation by half of the states would suffice. The rest of the Constitution could be amended by a special majority by Union Parliament. USA, it has a rigid constitution. It can be amended by the Congress by means of a special process provided by the Constitution for that purpose, where a special majority of 3/4 plus ratification by 3/4 of the states is required. Britain, it has flexible constitution. It requires no special procedure for its amendment and can be amended by the Parliament in the same manner as ordinary laws are made. France, it has rigid constitution and needs special procedure. 60% majority votes in both the House of Parliament is needed. Alternatively, President can call a national referendum on constitutional amendment. Japan, it has rigid constitution and requires special process. The amendment shall be initiated by the Diet. Such a proposal must be passed by a majority of 2/3 vote of its membership. After that, it is submitted to the people for ratification at a special referendum or special election. Germany, it has rigid constitution. Article 79 states the basic law may be amended by an absolute 2/3 vote majority of the Bundestag along with a simple 2/3 vote majority of the Bundesrat, excluding amendment of those areas defined by the Eternity Clause. Unitary or federal. Federalism is a system of government in which sovereignty is constitutionally divided between a central governing authority and constituent political units. Unitary system is governed constitutionally as one single unit with one constitutionally created legislature. Comparison of unitary or federal constitution of India with other countries is given below. India, it is federal system with unitary bias. Though normally the system of government is federal, the constitution enables the federation to transform itself into unitary state in emergencies. Federal features such as division of power, written constitution, supremacy of constitution, rigid constitution, independent judiciary, bicameralism, etc. are some of its core features. Some non-federal features are single constitution. Constitution has made center very strong by vesting more powers in it, such as governor is appointed by president, parliament can change the territories, borders and names of states by simple majority. Article 3. Black circle constitution is more flexible than rigid. Single citizenship. Single integrated judicial system. USA, it is a federal state. The Constitution provides for division of power between central government and state government. Residuary powers are vested in the states. Each state has its own constitution, elected legislature, governor and Supreme Court. Great Britain, it is a unitary state and all powers are vested in a single supreme central government. The local governments are created only for administrative convenience and they derive their authority from central government, which can also abolish them altogether at any time. France, it is a unitary state. The local government are created and abolished by central government only for administrative convenience. Japan, Japanese constitution provides for a unitary state. Type of government. India, the Constitution of India provides for a parliamentary form of government both at the center and in states. The parliamentary system of government is largely based on the British parliamentary system. Constitutional framework. 47. Important features of Indian parliamentary system are as follows. President is the nominal executive and prime minister is real executive. The political party which secures majority seats in Lok Sabha forms the government. The Council of Ministers is collectively responsible to the Lok Sabha. Ministers are members of both legislature and executive. The lower house can be dissolved on the recommendation of Prime Minister. USA, it has presidential form of government with following features. President is both head of state and head of government. The president is elected by an electoral college for a fixed tenure of 4 years and cannot be removed by Congress except by process of impeachment for a grave unconstitutional act. Black Circle President governs with the help of a cabinet, an advisory body whose members are selected and appointed by him and can be removed by him at any time. The president cannot dissolve the House of Representatives, lower house of Congress. The president and his secretaries are not responsible to Congress for their acts. Great Britain, it has parliamentary form of government where king is the nominal executive. France, it has quasi-presidential and quasi-prime ministerial system. On one hand, it provides for a powerful president, who is directly elected by the people for a 7-year term. On the other hand, there is a nominated council of ministers headed by Prime Minister which is responsible to the parliament. Japan, it has parliamentary system with largely British parliamentary features except for the following. In UK, the Prime Minister is chosen as well as appointed by King, Queen, but in Japan, Prime Minister is chosen by Diet but appointed by the Emperor. In Britain, ministers are appointed by King, OG, Queen, but in Japan by Prime Minister. In Britain, Prime Minister cannot remove ministers, but in Japan Prime Minister can remove. In Britain, all ministers must be members of Parliament. In Japan, only majority must be members of Diet. Parliamentary sovereignty. Parliamentary sovereignty is a concept in the constitutional law of some parliamentary democracies. It holds that the legislative body has an absolute sovereignty and is supreme over all other government institutions, including executive or judicial bodies. The concept also holds that the legislative body may change or repeal any previous legislation and it is not bound by written laws or by precedent. India, its parliament works on the principle of constitutionalism, i.e. limited government. It can make, amend, substitute and repeal any law, subject to judicial review. The parliament can make constitutional framework. 47. Important features of Indian parliamentary system are as follows. President is the nominal executive and prime. Minister is real executive. The political party which secures majority seats in Lok Sabha forms the government. The Council of Ministers is collectively responsible to the Lok Sabha. Ministers are members of both legislature and executive. The lower house can be dissolved on the recommendation of Prime Minister. USA, it has presidential form of government with following features. President is both head of state and head of government. The president is elected by an electoral college for a fixed tenure of 4 years and cannot be removed by Congress except by process of impeachment for a grave unconstitutional act. Black Circle President governs with the help of a cabinet, an advisory body whose members are selected and appointed by him and can be removed by him at any time. The president cannot dissolve the House of Representatives, lower house of Congress. The president and his secretaries are not responsible to Congress for their acts. Great Britain, it has parliamentary form of government where king is the nominal executive. France, it has quasi-presidential and quasi-prime ministerial system. On one hand, it provides for a powerful president who is directly elected by the people for a 7-year term. On the other hand, there is a nominated council of ministers headed by Prime Minister which is responsible to the parliament. Japan, it has parliamentary system with largely British parliamentary features except for the following. In UK, the Prime Minister is chosen as well as appointed by King, Queen, but in Japan, Prime Minister is chosen by Diet but appointed by the Emperor. In Britain, ministers are appointed by King, OG, but in Japan by Prime Minister. In Britain, Prime Minister cannot remove ministers, but in Japan Prime Minister can remove. In Britain, all ministers must be members of Parliament. In Japan, only majority must be members of Diet. Parliamentary sovereignty. Parliamentary sovereignty is a concept in the constitutional law of some parliamentary democracies. It holds that the legislative body has an absolute sovereignty and is supreme over all other government institutions, including executive or judicial bodies. The concept also holds that the legislative body may change or repeal any previous legislation and it is not bound by written laws or by precedent. India, its parliament works on the principle of constitutionalism, i.e. limited government. It can make amend, substitute and repeal any law, subject to judicial review. The Parliament can make constitutional laws by the same procedure as ordinary laws, only in few instances. UK, there is no system of judicial review in UK law. Parliamentary laws cannot be declared as invalid by judiciary as being unconstitutional. France, it has a parliament with limited powers vis-a-vis political executive. It can only make laws on those items which are defined in the Constitution. On all other matters, government is empowered to legislate by executive decree. France has a constitutional council with 9 members who are appointed for a term of 9 years. It functions as a judicial watchdog. It is only an advisory body. Constitutional supremacy and judicial review. In India, Japan and USA, the written constitution is regarded as the highest law of the land and Supreme Court acts as custodian of the Constitution through its power of judicial review. But there are differences. American Supreme Court does not derive its power of judicial review from Constitution, but Indian and Japanese Supreme Court does so. (48) General Studies, Mains, Paper 2. Constitutional Monarchy versus Republic. A republic is a form of government where head of state is elected, not hereditary. In essence, the word republic connotes ownership and control of a given state by the population at large. The post of head of state of a republic is usually held by one person, i.e. the president, who may be appointed or elected by the prime minister or the population at large respectively, depending on the constitutional arrangements and essentials. A constitutional monarchy is a form of government established under a constitutional system which acknowledges a hereditary or elected monarch as head of state. Republic countries: India, USA, France, Germany, Russia. Constitutional monarch: UK, Japan. Role of president. India: the President of India is the nominal head of state of the Republic of India. The real executive is Council of Ministers headed by the Prime Minister. The President has to exercise his powers and functions with the aid and advice of Council of Ministers headed by Prime Minister, Article 53, 74, 75. The President is indirectly elected by the people through elected members of the Parliament of India, Lok Sabha and Rajya Sabha, as well as of the state legislatures, Vidhan Sabhas, and serves for a term of 5 years. President can be removed from his office before completion of term by impeachment for the violation of Constitution. USA President of the United States of America is the head of state and head of government of the United States. The President leads the executive branch of the federal government and is the Commander-in-Chief of the United States Armed Forces. President holds his office for a fixed term of 4 years. He is eligible for re-election but only once. He can be removed from his office before expiry of his term through impeachment proceedings for treason, bribery, or other high crime. Article 2 of the U.S. Constitution vests the executive power of the United States in the President and charges him with the execution of federal law alongside the responsibility of appointing federal executive, diplomatic, regulatory, and judicial officers and concluding treaties with foreign powers with the advice and consent of the Senate. The President is further empowered to grant federal pardons and reprieves and to convene and adjourn either or both houses of Congress under extraordinary circumstances. France: the President is the pivot of the Constitution and occupies a dominant position in the system of government. He is the real head of the state. The President is directly elected by an adult suffrage. The length of the term was reduced to 5 years from 7 years. A president cannot serve more than 2 consecutive terms. The president can be removed from the office through an impeachment process for high treason. The impeachment resolution should be passed by both houses of parliament by an absolute majority. After this, president is tried by High Court of Justice. Germany: the President of the Federal Republic of Germany has mainly ceremonial and supervisory duties as Germany is a parliamentary system of government. President can give direction to general political and societal debates and has some important reserved powers in case of political instability. All federal laws must be signed by the President before they can come into effect. He can only refuse to sign a law that he believes to violate the Constitution. The President is elected by the Federal Convention, a body established solely for that purpose. While in office, the President enjoys immunity from prosecution and cannot be voted out of office or recalled. The only mechanism for removing the President is impeachment by the Bundestag or Bundesrat for willfully violating German law. Constitutional framework. 49. Once the Federal Constitutional Court is tasked with determining if he or she is guilty of the offense. If the charge is sustained, the court has authority to remove the president from office. Citizenship. India. The Constitution of India provides only single citizenship for whole of India. The provisions relating to citizenship upon adoption of the Constitution are contained in Articles 5 to 11 in Part 2 of the Constitution of India. But Government of India is increasingly becoming more flexible with regards to its dual citizenship rules for overseas citizens of India. USA. The citizens of USA may acquire foreign citizenship by marriage, or a person naturalized as a U.S. citizen may not lose the citizenship of the country of birth. U.S. law does not mention dual nationality or require a person to choose one citizenship or another. Also, a person who is automatically granted another citizenship does not risk losing U.S. citizenship. However, a person who acquires a foreign citizenship by applying for it may lose U.S. citizenship. In order to lose U.S. citizenship, the law requires that the person must apply for the foreign citizenship voluntarily and with the intention to give up U.S. citizenship. Fundamental rights. Indian Constitution has certain fundamental rights modeled on American Bill of Rights. But unlike USA, fundamental rights in India are not absolute, and hence government can impose reasonable restrictions on them. Whether the restrictions are reasonable or not is to be decided by the courts. USA. The Bill of Rights lists specifically enumerated rights. The Supreme Court has extended fundamental rights by recognizing several fundamental rights not specifically enumerated in the Constitution. Note similarly, the Constitution of USSR and Japan also guarantees certain fundamental rights, but there are no such rights enumerated in the Constitution of Great Britain. Due process of law and procedure established by law. Due process. It is the legal requirement that the state must respect all of the legal rights that are owed to a person, and laws that states enact must conform to the laws of the land, like fundamental rights, liberty, etc. It also gives the judiciary authority to examine the fundamental fairness, justice, and liberty of any legislation. Procedure established by law. It means that a law that is duly enacted by legislature or the concerned body is valid if it has followed the correct procedure. Say a law enacted by Indian legislature. Article 21 of Indian Constitution says that no person shall be deprived of his life or personal liberty except according to procedure established by law. UK. While for becoming a British citizen, one does not need to give up one's present citizenship or nationality. One will not normally lose British nationality if she becomes a citizen or national of another country. France. Dual citizenship has been permitted since 1973. Possession of one or more other nationalities does not, in principle, affect the French nationality. Germany. Dual citizenship is allowed under certain circumstances. Australia. With effect from the 4th of April 2002, there are no restrictions under Australian law on Australians holding the citizenship of another country. Emergency provisions. India. Part 18 of the Constitution of India contains Articles 352 to 360, which deals with emergency provisions. There are three kinds of provisions according to the Constitution. 1. National emergency. It is proclaimed on the ground of war, external aggression, or armed rebellion. Article 352. 2. State emergency. Earlier it was misused quite often, but with judicial ruling in S.R. Bommai case and rise of regional parties, it's no longer misused. Article 356. 3. Financial emergency. This type of emergency has never been declared so far. Article 360. 50. General Studies, Mains, Paper 2. Australia. Unlike India, state of emergency legislation differs in each state of Australia. Canada. The federal government of Canada can use the Emergencies Act to invoke a state of emergency. A national state of emergency automatically expires after 90 days, unless extended by the Governor in Council. There are different levels of emergencies: public welfare emergency, public order emergency, international emergency, and war emergency. France. Three main dispositions concern various kind of state of emergency. In France, Article 16 of the Constitution of 1958 allows, in time of crisis, extraordinary powers to the President. Article 36 of the same Constitution regulates state of siege. Finally, the 3rd of April 1955 Act allows the proclamation, by the Council of Ministers, of the state of emergency. The state of emergency in France is framed by the Constitution of 1958, which states that it can be decreed by the President in the Council of Ministers, but must be confirmed by Parliament in order to be held after 12 days. Germany. In the post-war Federal Republic of Germany, the Emergency Acts state that some of the basic constitutional rights of the Basic Law may be limited in case of a state of defense, a state of tension, or an internal state of emergency or disaster, catastrophe. USA. United States, there are several methods for government response to emergency situations. A state governor or local mayor may declare a state of emergency within his or her jurisdiction. This is common at the state level in response to natural disasters. The President of the United States, as head of the executive branch, has the authority to declare a federal state of emergency. The only emergency provisions in the U.S. Constitution are: the privilege of the writ of habeas corpus shall not be suspended, unless when in cases of rebellion or invasion the public safety may require it. Working of Indian Constitution. An analysis. The working of the Constitution has stood the test of the time, but certain recent developments such as fragmented polity, rise of regional political parties and governments formed by regional parties in the states, e.g. in Tamil Nadu, Bihar, West Bengal, etc., has posed new challenges for the center-state relations. Similarly, the advent of coalition government post-late 1980s has raised certain questions for which Constitution provides either ambiguous answers or no answers at all. Considering the complexities and huge quantum of the task of modern-day government and changing nature of Indian politics, there is a need to review and amend the Constitution. Some of the areas in which amendments are required are given as under. Those candidates who face corruption and criminal charges should not be allowed to contest the elections. Frequent disruptions of parliamentary sessions have become the norm of the day. Minimum hours for which Parliament has to work should be incorporated in the Constitution. Changes in civil services rules to ensure impartiality and neutrality. The fundamental rights under Part 3 of our Constitution too need to include many of those rights that have developed over a history of various judicial pronouncements. These rights, though not really stated in Part I, have been recognized as fundamental in nature and are better known as implied fundamental rights. E.g., right to food, right to livelihood, right to clean potable drinking water, right to fresh and clean environment.
अंदर करा जो लावड्याला दिसते म्हणून अंतर दिसते